to Crime in Court. This is the 1996 Menendez brothers retrial. Eric and Lyle Menendez on trial for the homicides of their parents, Kitty and Jose. We are on the defense's case, part 21 now. We just in the last part we did, Dr. Charles Morton came to the stand. He testified a little bit on direct, and he hasn't completed his direct yet. But now, this next day, so we're coming back Friday, December 1st, 1995, and right at the beginning, you're going to hear that Ms. Abramson is not feeling well. So I believe they just send the jury home, and they do a little bit of argument. So that's what we're going to go over, is the arguments that they do outside the presence of the jury today on what is December 1st, 1995. And then, if you remember, we had Dr. Cyril Wecht, who is he a pathologist? I want to say a pathologist, or he is a medical professional, and he testified very briefly like a week ago in trial time. So he was on the stand a week prior to or actually this Monday of this week, and then they had to go to other witnesses, if you remember, because Cyril had other things, they had to call him back. So he's going to be coming back to the stand after this day, today's stream. So just kind of giving you reference of what is going to be happening. And then Dr. Morton's going to be coming back at a later time. It's confusing and it's all out of order, but that is what it is because of, you got to schedule your witnesses, and sometimes you can't get them back to back. So that's what's happening today in this stream. We're going to go over just the argument, no jury, and then we'll be done there. And then tomorrow we'll pick up with Cyril Wecht's testimony. One other thing that I wanted to say, and I forgot to mention it in yesterday's stream because I'm pre-recording these, so I just forgot what day it was going to be airing. But this, I believe this is airing Tuesday, and that means that the brothers' parole hearing is 2 days away. So, if you remember a little while ago, Eric Menendez wasn't feeling well. He had some kidney stones and some other things where he needed surgery. He had multiple surgeries done, and then he was at the hospital for all of these, and then they returned him back to the prison for recovery. He is doing better. He's doing okay. He's recovering and will be hopefully up and ready to, well enough to be able to go to these parole hearings and do his best, because I think they both stand a really good chance at parole. So that is some exciting news that we have going on this week. So Thursday and Friday, yes, Thursday and Friday of this week are the parole hearings. So I'm sure I will do some kind of follow-up video just on that, separate from the trial transcript. So look out for that as well. All right. And don't get your hopes up and think that they're going to be released immediately, because it still needs to go through, the governor's desk, and he needs to approve or deny or whatever. He needs to review it. So don't get your hopes up and think that they're going to be released this week. Just know that, it could take a little while still for um, an answer, a resolution to the parole hearings. All right, so let us get started here. Please hit the like button. Like I said, we're on the defense's case, part 21. We're going to just get into it because they just get started right in their morning. So the following proceedings were held in open court, and again, no jury present. And the court says, in the trial, the defendants are in court, their lawyers are here, the people are here. Ms. Abramson. She says, Your Honor, I followed the court's advice, but I'm not feeling better. I'm feeling worse. I believe I'm running a fever. I'm very nauseated. More importantly, I'm very dizzy and have blurred vision. It's very difficult for me to stand up. So I'm asking the court's indulgence to recess. The court says you don't feel you can function today. I don't feel I can function today. The court says, okay, there's not much we can do with the jury present. Is there anything that counsel feels that we can do with the jury without Ms. Abramson's participation this morning? Mr. Gessler says, I can't see how we can, Your Honor. Ms. Abramson says, try out our final arguments. The court says, something someone would like to try out, perhaps? Ms. Abramson says, we can try out our final arguments. The court says, all right, then we'll have the jury come out and I'll explain the situation to them, and I am going to inquire of them as far as any exposure they've had to the case outside of the courtroom. So we'll do that this morning. So I wanted to point out okay, so where are we? December 1st. Okay, so here is the my spreadsheet that I have. We're on week 8. So we just completed Charles Morton for November 30th. December 1st, we're about to begin, or we just started. And so that is 8 weeks, 2 months that Ms. Abramson has pretty much done a ton of heavy lifting on, not just the defense's case. So we're on the second week of the defense's case, technically like a week and a half, because the first week was Thanksgiving, so there were only 3 days. But so now we're on Friday of the first full week after that Thanksgiving Day week. And that's where we're at. And so I just wanted to point out that I'm sure it is physically, mentally straining. And she's a trooper for coming this long without getting sick. So just wanted to point that out. We I think there was something else I was going to say. We're going to come back next week. And while I have this up, we'll just go over this really quick. So we're going to come back next week. Cyril Wecht, who's a forensic, I was right, he's a forensic pathologist. He will be on the stand Monday, December 4th. Then Charles Morton will return for Tuesday, Wednesday. Robert Anderson, who was the boat operator, if you guys remember from the first trial, well, they talked about it in this trial too, but it's been a while. The weekend of the homicides, the day before, the brothers were supposed to go on this shark fishing trip with their parents, and they were trying to like spend all day out of the house to avoid going because they thought that their parents were going to take their lives on that fishing trip. And so that will be discussed. And then we will get to finally Eric Menendez. So just giving you a heads up of where we're at for right now. Dr. Cyril Wecht and Dr. Charles Morton did not testify in the other trials, or in the first trial, I should say, but Robert Anderson and obviously Eric Menendez did. So there you go. Oh, but Robert Anderson, that's a change. He testified for the prosecution in the first trial. This time he's testifying for the defense. So that'll be interesting. So we'll just to give you a heads up, that's what's coming. So let us get started. Okay, or well, let's continue. We already started. So let's continue. The court says, all right, Then we'll have the jury come out and I'll explain the situation to them. I'm going to inquire, blah, blah, blah. The jury comes out. The court says, okay, the jurors are all here. Ladies and gentlemen, I'm sorry for the delay. Ms. Abramson has not been feeling well this morning and suffering from what sounds like flu like symptoms, and it's gotten worse rather than better. And she doesn't feel well, or she doesn't feel that she can continue with the direct examination of the witness. And that is all that was scheduled today. And we were also scheduled to take a break at noon to accommodate the scheduling of one of the jurors and also of counsel. So there's not much we can do today. So it looks like we're going to get an early start, at least you will on the weekend. But before I excuse you for the weekend, let me go back to the inquiry I've made of you on earlier occasions, whether or not any of you have been exposed to anything about the case in any form outside of the courtroom that we have yet to talk about, or that this occurred since we last spoke. If you have, would you raise your hand so we can discuss it? Okay, nobody has. All right, then unfortunately, we can't proceed today. I'm sorry for the inconvenience. Hopefully, everybody will be healthy and happy and wise and ready to go on Monday. So, have a good weekend. Don't discuss the case with anyone. Don't form any final opinions about it. Don't permit yourselves to be exposed to anything about the case outside of the courtroom, and we'll see you back here on Monday, 8:30. The jury exited the courtroom and the following proceedings were held. The court says, okay, the jury has left. There has been held in abeyance a hearing and argument on the defense motion pursuant to section 111 or 11118.1. Is counsel going to proceed with that today? May I have a moment, Your Honor, says Ms. Abramson. Defense attorneys Gessler and Abramson confer. Ms. Towery says, while they're conferring, Your Honor, we had a dispute about I think it was Exhibit 153, that the court ordered redacted, and Ms. Nahara had an objection. What I did is left in the first sentence. The court says, yeah, that's too much. Miss Towery says, let me just explain my reasoning. That I inquired about the bird, which is referenced in the first sentence, and it looked so strange to redact that out that I thought the court might prefer to leave that in since it's not prejudicial and it looks so weird to have one sentence on the page. So if the court wants it redacted, that's fine. I just thought it might be less prejudicial to leave it that way, to leave it the way it is. Sorry. Court says, no, I think it should just be as I indicated, that one quotation that was referred to in the transcript. Ms. Tari says, okay, if I can have that returned, I'll just take that sentence out. Court says, okay, let me inquire of counsel then. Is the defense able to proceed with a 118.1 motion at this point? Mr. Gessler says, yes, Your Honor. The court says, you'll make the arguments for both defendants? Yes, Your Honor. I think that the proceedings are basically for both defendants, at least concerning the constitutional principles involved of the narrowing function of lying in wait. The 118.1 as to how the evidence is insufficient to support it is slightly different as to each defendant, but not to a great degree. Court says, okay, is it then agreed by all defense counsel that we proceed with the motion at this time? Mr. Gessler says it's agreeable on behalf of Joseph Lyle Menendez. Yes, Your Honor, says Ms. Abramson. Court says, okay, go ahead. Mr. Gessler says the first thing I'd like to do proceeding the 118.1 is that I had objected to the charts, as the court knows, the 24 exhibits that are called 1A through 12B, and the court did find under 352 that they have relevance and also that they met enough expertise apparently over my objection to be admitted. I just wanted to make sure that the court understood that those objections were also made on constitutional grounds of due process, that these pictures are, in our opinion, so invalid from any scientific basis. I like that. The pictures from failure analysis are so invalid from any scientific basis whatsoever, given the testimony of Dr. McCarthy, and so misleading to the jury, inasmuch as they portray visually with so-called rods, number one, a straight line instead of what we all know as a conical type distribution of shot as it emits from the shotgun and goes at a distance. Nobody may be able to say when that cone takes a certain shape, but certainly it is conical and gets bigger as it goes forward, which is not displayed by the green rods that Dr. McCarthy has used on his exhibits. In that respect, it is misleading to the jury, as well as, in our view, the angles are misleading to the jury in that Dr. McCarthy, said finally, they represent only one of many variables, depending on where the limbs were, the position the head was in, the position in which the shooter was. They portray visually one out of numerous possibilities. And that is one of the reasons that we feel they should not be admitted under 352, as well as no scientific basis for that particular one that's displayed as well as the others. The reasons that it's also, I believe, a violation of the federal due process clause of the Constitution is that this is a matter of such moment to the jury that it denies the defendant's due process of law in a fair trial because they're talking about 24 exhibits. So this is so egregious, he's saying, that it violates the Constitution, that they are putting in these unscientific, unverified images to try to portray some kind of something to the jury when he's flat out said on the stand that they're not accurate. What do you think the judge is going to do? I have a feeling he's going to allow them in. Let's see what happens. Granted, we've had 320 something exhibits marked, but even then, 24 exhibits is a substantial part of it. Not to mention the sub exhibits that were used by defense counsel in order to try to discredit the major exhibits. So we're talking a substantial portion of the case as displayed visually by these exhibits, and I think it has an impact on the jury that is highly prejudicial, and admitting those is highly probable that it will have a substantial and injurious effect in determining the jury's verdict. And that's under Kotakos 328 US, and that's at page 776. It's the philosophy, and it's been adopted by the Ninth Circuit in a more recent decision of McKinney versus Reese. That is at 993 federal something at page 1378. That did not have to do with charts. That had to do with evidence concerning a knife that they found should have been inadmissible, but the purpose of that case is that it does show that the federal courts do look at constitutional violations under state law, even though the admission of evidence is normally considered to be a state law function. That admissibility of irrelevant evidence that arises to the status of harm and of being largely considered by the jury is the sense of the Kotakis case that it has a substantial and injurious effect or influence is then a violation of the federal constitution process clause. And I wanted to make sure that that was understood by the court to be a part of the objections that I was making to the exhibits of Dr. McCarthy. Court says, okay, I now do understand that that's part of the objection. Let me inquire, though. You withdrew the objection to his testimony that you initially made that caused us to conduct an evidentiary hearing, and then prior to his actual testimony before the jury, as I recall, you objected to basically testimony of McCarthy as to 2 shots and not as to all the other exhibits and testimony that he was going to offer. You didn't state an overall objection to his testimony when he took the stand before the jury, and then during his testimony, there were periodic objections to specific questions that were asked and rulings were made. And then all of the exhibits were shown to the jury at great length during his testimony. Even assuming you want to pursue the objection by not having the exhibits received by the jury and taking it to the jury room, they've seen them for day upon day here referred to during the testimony of McCarthy and the other witnesses. How is it that this point you can remove that from consideration? I think, Your Honor, Mr. Gessler says, that taking away the physical evidence, the physical exhibits, the oral, I mean the visual presentation in a pictorial or diagrammatic form still has value in that then it leaves them to having seen things, yes, and having heard oral testimony, but it doesn't raise it much above the value that any other oral testimony has. I think the vice here that we're trying to defeat, and this didn't come up until very close to the end of McCarthy's testimony when he finally backed off his position at the 801 hearing, which is I am the true savior who can give you the one and only way it happened. That's how McCarthy made it out to be. Is he finally said this is just an illustration, and yes, there are many ways where that vector or that angle could be drawn depending on where the things are moved. The vice of those physical exhibits coming into the jury, whether a month from now or 2 months from now, and seeing the physical representation there and forgetting the final oral passage in which he said this is just one of the numerous ways in which it could happen, that we're trying to avoid that, where the jury has them within the jury room, when the jury has when the jury then has with them in the jury room the one that is portrayed rather than the oral idea that it's one of many. The court says, well, my response is that by foregoing or abandoning your motion under 801 of the evidence code, you in essence waived the objections that you're now making to the receipt of those exhibits. Mr. Gessler says, well, I wonder, Your Honor, if we did, and I state it this way. Are we really in any different position, having gone through 2 days of testimony on an 801 hearing and then abandoning it, and then if we'd never heard 801 at all? Assume, for the purposes of this proceeding, that that was used as an offer of proof or whatever, but there was no 801 hearing then or ever, just our 402 hearing, that our 402 motion, which was not really a hearing that was stated before the judge. Are we really in a worse position legally and on a relevance ground than if we'd never made an 801 hearing? I don't think the 801 hearing really affects the relevance of the pictures that are being sought, the diagrams that are being presented. I don't think it affects the 352 aspects of it. All it does is say we withdrew our objection under 801 as though it had never been made. The court says, why did you do that? Mr. Gessler says, does it make a difference, Your Honor? The court says, I think it does. I don't think you have to tell them why, but the court wants to know. He says, I think it does. I think it sets the stage for all these exhibits to then be shown to the jury and have all this testimony be presented to the jury with the issues as they were being presented. How can you then say, we had our motion, we were pursuing it, but we abandoned it, but we now want to remake it? We were on full notice as to really what it was that was going to be occurring. Mr. Gessler says, Your Honor, we're not remaking it. I'm not remaking an 801 hearing. I'm making a 352 motion and a relevance motion and a motion that the promise that he made, whether we'd had an 801 or not, that this was geometry and mathematics and such. On cross-examination, that came out that's not so. Now, with or without an 801 hearing, with or without one that was abandoned, with or without one that was ever talked about, whether it had ever been made, not made, we're in the same position that when finally he said under cross examination, we're in the same position when finally he said under cross examination, there is no mathematical basis for this. No mathematical basis for his diagrams. They need to be removed from evidence. They should be excluded. Absolutely. There are no formulas. I have no figures. This is just my representation of one of many things. That's the point. At that point, when it became 352 excludable and irrelevant, and it would have made no difference how we got that far. That's the point at which, for the first time, I think we had a tenable 352 motion and motion to exclude on relevance and lack of scientific foundation. Court says, I think all of those issues could have easily been crystallized and addressed during the hearing that had been commenced and was abandoned. There was some reason why the defense chose to abandon it and proceed as you have. And you said, it's not really relevant to this discussion, but the bottom line is you did abandon it. And regardless of the court's analysis of your other arguments, I do find that you did waive the objections by abandoning that hearing. But we waived, but also, I think, Your Honor, I think under 352, they keep cutting each other off. The court continues on saying, I think under 352 of the evidence code, that was also clearly something envisioned by that hearing that was being conducted before the opening statements. It was something that solely was as you developed it during the testimony of McCarthy. He was in the middle of cross examination when you abandoned your hearing. It wasn't as though you had completed the cross examination and were unable or unaware of what it was that he was going to say. You stopped and you had your witnesses here ready to proceed with them and decided not to put them on. You decided to put it all in front of the jury. Mr. Gessler says, that's all true, Your Honor. Court says, and then you make a 352 objection after you've put it on in front of the jury. How can you do that? Miss Amerson says, Charlie, can I be heard? Mr. Gessler says, let me finish this thought. Then you're on. Your Honor, the first motion, and I think it was characterized as an 801 motion and also with Kelly Fry aspects, whatever those are, that's what we were preparing to do. And as I've said, whether it was withdrawn or for whatever reason or had never been heard, I don't think that precludes later findings under the or an approach to the court to apply 352 and relevance and whether or not there is scientific principles that were really used at the time that we did the hearing in the courtroom. I've never heard of a waiver of other objections by perhaps abandoning or not making one objection. And I respectfully take issue with the court as to whether or not we abandoned the 352 and all other approaches by leaving the 801 motion. Like I said, it's just as though we never made it. I know Ms. Abramson wants to address the court. Can she remain seated? The court says, sure. But what I'm saying is that I envision the hearing that we conducted before opening statements where we took testimony as a hearing dealing with the overall ability of Dr. McCarthy's testimony. Ms. Amerson says that's not what the court says, and then thereafter, when that was withdrawn, we were left with specific objections to portions of his testimony or questions that were asked and things of that nature, not the overall admissibility of his testimony. Mr. Gessler says, I don't think, Your Honor, that we even had the 24 exhibits that I am now talking about at the time of the 801 hearing. Those were revised by Dr. McCarthy at the time that we began the trial, not at the time of the 801. Those 24 specific exhibits were not even in existence. We had a precursor to them, or precursors, through the device of the show box there and the computer, and we had some other drawings. Ms. Amerson says, I'm very confused. Mr. Gessler says, I know, of people sitting there, but not the same of the 24 exhibits that I am now addressing. Now I'll let Ms. Abramson clear it up. Thank you, she says. Your Honor, we all went through an evolutionary and educational process concerning what it was that Dr. McCarthy was going to testify to. What we were originally presented with, which was the basis for our making an 801 objection, an objection that what he was going to do was beyond what was acceptable in any scientific community. It was based on a report in which he purported to know what was in the minds of the shooters at the time of the shooting, in which he purported to know what was being aimed at based on what was hit, in which he had theories of why the shooting was done in a particular way, and in which he offered, and we knew he had consulted with no medical experts, medical opinions that were contrary to what the coroner's office was saying, in which he offered opinions about ballistics and shot patterns that were contrary to what ballistics experts that we had consulted were going to say. So there was. At this point, when we asked for that hearing, there was a wide range of pseudoscientific stuff in his and psychological stuff in his report, which is what we were seeking to prevent him testifying to because he and just about anybody, with the exception perhaps of the Almighty were not in the position to render those positions. That's when we scheduled the hearing, Your Honor, because he was trying to speculate the minds of the individuals involved in the crime, both the decedents and the defendants. When the hearing began, we learned for the first time that he had created these little cartoons, now called illustrations, and the way he presented them in that hearing, which is the first we ever saw of them, was that these were reenactments based on engineering principles. Now, whatever else I may have learned about Dr. McCarthy, I do believe he is a qualified mechanical engineer. And if indeed he was going to present things that were based on valid engineering principles, I did not believe that an 801 lies towards those things. What I was concerned, so she thought, like, because his credentials are in mechanical engineering, she thought, oh, I don't have a problem with him being an expert in mechanical engineering, like talking about the guns and stuff. Whereas he testified to the people, which is not what you're supposed to do. As a mechanical engineer, you deal with the machines, the physics on machines and items, things. Whereas you're going to, as a biomechanical engineer, you're going to look at how the physics react or affect a human body. So he played the role of both mechanical engineer, biomechanical engineer, um, blood spatter expert, criminologist, all sorts of things. Doctor. He was everything all in one. But that's not what the original 801 was to determine his credibility, and she didn't have a problem with him being a mechanical engineer, but that's not what he testified to. So that's the problem. She says, what we were concerned with was preventing a mechanical engineer from being a ballistics expert. Exactly. From being a medical expert, from being a blood spatter expert, and all these other areas of expertise that he didn't have. As the court may recall, it was only after his little show and tell on direct in the 801 hearing that we obtained our first set of images of these illustrations, and we were asking, even at that point, for the engineering calculations, or as Dr. McCarthy calls them, the geometry that lay behind the creation of these drawings, and we were misled into believing such a geometry existed because the engineer was claiming that these were a product of, all of the work for over a year and the contribution of every department of the most genius laden organizations in America's jurisprudence, making it seem like this is the golden key of all evidence. In any event, what became obvious during the course of the hearing was that the court was not going to allow Dr. McCarthy to offer opinions on medical areas where he wasn't qualified because you sustained objections during the hearing on that basis. What became obvious from remarks that the court made, what became obvious from remarks that the court made and also from sustaining objections was that the court wasn't going to allow him to talk about what people are thinking, and what also became obvious during the course of the hearing was that the prosecution was going to try to protect his credibility by not going into the more outrageous and outlandish aspects of his report, which are the things that made us bring the hearing. Now, in all candor, Your Honor, what we believed would be the outcome of the hearing, if we had carried it through, was that the court may have ruled that there was certain kinds of opinions that Dr. McCarthy could not offer, but we had no reason to believe, and we certainly couldn't know, that the court was going to exclude him from testifying altogether because the way that he was portraying it at that hearing, there was something that engineering had to contribute to his so-called reconstruction. And we came away, and rather than continue our cross examination and reveal to this witness all the ways in which we intended to show he was wrong, we decided, okay, we can get him limited so we won't have to go out of range and then deal with the so called engineering. And that is why we withdrew the 801. Nothing sinister. And subsequent to that, we made the point with which this court adopted, we made the point which this court adopted that he could not render medical opinions on his own. Well, then why did he? There had to be medical foundation for those opinions. And as a consequence, the prosecution went out and found him a doctor, or rather, he went out and found the prosecution a doctor, someone who could be sufficiently flippy floppy as to give him, as the court ultimately ruled, even though we objected that Mr. McCarthy or Dr. McCarthy was not really relying on the medical expertise of Dr. Lawrence or Dr. Golden. Nevertheless, Dr. Lawrence, the court ruled, gave him enough room so that there was some medical basis for some of the things he was trying to show in the reconstructions. But in fact, it was only during his testimony at trial that we learned that the cartoons are purely imagination on his part. Beautifully said. Beautifully said. The cartoons are purely imagination on his part. There was no scientific basis for the illustrations, and clearly our 801 was not aimed at illustrations. What we didn't even know existed until we were in the middle of the hearing, and they've been changed. We never did get the data of any calculations or computations. All of that discovery was subpoenaed to be going on after the 801 hearing ended. What we finally learned was that they withdrew them by accepting the measurements that the Beverly Hills Police Department had made, that in spite of Dr. McCarthy's assertions to the contrary, his computer doesn't scale things accurately and hadn't scaled the furniture accurately, and basically that's the only science that was ever involved, and we learned only during his examinations in the creation of the illustrations, that is, getting the computer to take numbers and then scale the images to the numbers that it's fed. And so it's only really after he was fully examined that it comes out that this is no more than Roger McCarthy's imagination drawn up this way. This is no more than Roger McCarthy's imagination drawn up this way. And because they are visual impressions, because they are very large, because they purport to show not just positions, but a sequence that it became obvious he couldn't really support scientifically, that's why we're objecting to the illustrations. So, it's really not fair, I guess, to say that we just pulled a tactical trick, or the implication that we just pulled a tactical trick in the 801. The only tactical trick is we thought he'd be limited to testify in some limited way, and I didn't want to reveal to him all the things we could hit him with, frankly. So she didn't want to keep going with the 801 because she didn't want to reveal all of her sources for impeachment. She didn't want to get him. She didn't want to go hard at him until trial. So I get that. But the problem of the illustrations is different than the problem of his testimony. The court did rule he needed a medical foundation. The court did sustain objections through trial to his going too far afield of whatever his qualifications may be. The illustrations, I think, are a separate issue. Thank you, Your Honor. Court says, all right, any response? And here's what the state says in response. Mr. Khan argues for the state and says, yes, clearly what we have here on the part of the defense counsel is a series of tactical decisions that they made with their eyes open at all times, knowing exactly what they were doing and seeking, essentially, to have their cake and eat it too. Really? Really? They're just trying to defend their clients in the best way possible. It's not some tactical, sneaky decision to get you guys. They're trying to defend their clients. They want to first allow in the testimony, put in their rebuttal, and then once the rebuttal is in, to then have the testimony thrown out. Ms. Abramson says, we're not moving to strike the testimony. Mr. Khan says, if I can please speak. Whoa, okay. And I don't think that the court should fall for this tactical maneuver for their part. They were provided not only with the report as much as they want to claim ignorance and not understand fully what was in the report. Dr. McCarthy provided sufficient information in that report to put counsel on notice as to what he was going to testify to, and then the court also allowed a hearing, and it was in that hearing that they had a full opportunity to cross-examine Dr. McCarthy and the basis for his opinions, and they did so at length. We had a lengthy hearing in which they were able to question him concerning the basis for opinions. And once again, they want to feign ignorance and say, we had no idea what this man was talking about. We had no idea what he was going to be testifying to. We had no idea what the basis for his opinions were. And I don't see how competent defense counsel can sit there and say that they had no basis. After days of cross examination of this witness as to the basis for his opinion, it was their job to elicit from him the basis for his opinion. That was the whole purpose of the hearing, to find out the basis for his hearing or for his opinion. And now, after hearing, or start again. And now, after having days to do so, they sit there and pretend that they're ignorant and say, gee whiz, we didn't know what this man's opinion was based on. Well, the truth of the matter is, they had plenty of opportunity to cross examine him, and it should have been clear to any attorney and to anyone in the audience at that point what the basis of his opinion was during the course of that hearing. And it was their responsibility at that time to make a tactical decision to pursue the motion under 801 or to withdraw the motion under 801, and they chose, with their eyes fully open as competent defense lawyers, to withdraw the motion under 801. Then we have the testimony presented at trial, and after they've listened to the testimony at trial, then they have another tactical decision to make. And that tactical decision is, do we move to strike his testimony at this time, or do we go ahead and rebut? So, what do they decide to do? They go ahead and rebut. We have been listening to days of testimony now from various defense witnesses talking about how reconstruction is not possible. They made their tactical decision. They have to live with that tactical decision. And now they're saying, oh, by the way, now that we have all of our evidence in, all of our rebuttal in, we want to go back and strike the testimony. That, I think, that motion is simply not timely, that the court should deny the motion. And when you look at the tactical decisions that were made in this case and the timing of those tactical decisions, I think that the motion should be denied. Mr. Gessler says, I think the counsel missed a point, Your Honor. I'm sorry if he thought we were moving to strike testimony. We're not. We're moving to object to 24 exhibits. That's how this came up. That's how it's still up. Testimony, that's okay. We have decided to fight the testimony, I think, successfully. The district attorney may think unsuccessfully. It makes no difference. But the 24 exhibits stand on their own, and they do not have foundation to be accepted, Your Honor, under the federal constitution or under state law. They do not have foundation under both federal and state laws. The court says, all right, so you're not asking that his testimony, McCarthy's testimony, be stricken? No, I'm asking that the 24 exhibits be denied entry. Mr. Khan says, if I may respond to that, as far as the exhibits are concerned, the exhibits do nothing more than illustrate his testimony. And the important thing to note, yeah, they do nothing more than illustrate his testimony, sure, even though his testimony said that you can't take his illustrations for fact. So why are you putting them into evidence? It makes no sense. And the important thing to note about the exhibits is that they do not come without clarification or explanation. We heard from Dr. McCarthy, and he explained the limitations of each and every single one of these exhibits. He explained that the green bar does not represent a stream of pellets, but it is designed to represent a cone. And counsel argues that that's insufficient because when the jury decides this case, they're going to forget his testimony in that regard. Well, that's the job of defense counsel, to make closing argument in this case and to remind the jury of what he said. None of this testimony comes in with guarantees that the jury is going to remember everything that a witness says. That's why counsel has argument. Counsel can do his job, remind the jury of that, and they'll be able to recall all of the limitations that Dr. McCarthy placed on those illustrations. Mr. Gessler says, that's not the point, Your Honor. The point is that the exhibits, as now set forth, with the rods and with the testimony of Dr. McCarthy, are misleading. They do not show what they purport to show. The court says, all right. We did have a similar discussion on Monday when the exhibits were offered and received, and at that time the court indicated that the exhibits were in fact illustrative of his testimony of Dr. McCarthy and give meaning to his testimony and give meaning to the testimony of basically every witness who has testified since he was on the witness stand. Because everybody has referred to those exhibits, and it would be meaningless for any person reviewing the testimony of McCarthy or those who followed if they didn't have access to those exhibits. They wouldn't understand what it was that was being said and why it was being said and what the testimony meant, and that's the purpose of the exhibits. Demonstrative evidence to assist in understanding the testimony and understanding what it is that it's described, and that was why these illustrations were utilized. And so, my statement for reasons at the time the exhibits were received this past Monday remain valid reasons. They are illustrative. I don't find them to be misleading. They certainly are subject to clarification and limitation based upon the testimony of Mr. McCarthy and those witnesses who have testified about them, and it's clear that these are not designed to be depictions of the events as they actually happened, only illustrations of Dr. McCarthy's theory of how these events happened, with the understanding that the illustrations don't depict the precise positions of individuals in precise angles, but approximations. Does the jury understand that? Do they understand that the illustrations are not to depict what actually happened, but to show McCarthy's idea of what it should show? With those modifications that have been amply brought out by counsel in the examination of witnesses, these illustrations are not prejudicial and are not confusing or misleading, and therefore the restated objections of the defense to their receipts are overruled as they were on Monday. Yep, they're coming in. Mr. Gessler says, I would like to make one comment, Your Honor. The court has said that reviewing authority must be able to have access to these 24 exhibits to know what they've been talking about. Denying them admission into evidence would not deprive the reviewing authority from seeing those. They would still be available to an appellate court, certainly. The court says, I was referring to the 12 people who will review all of the evidence in this case and make a decision, meaning the jury. And those people are sitting in the jury box. I wasn't talking about a reviewing court reviewing the record, but the jury who has seen all these witnesses testify and going into a jury room and trying to piece together what it was that they were saying without the exhibits would be an insurmountable task. If you say so, sir. They need those exhibits to illustrate the testimony that has been presented here. Mr. Gessler says, which was exactly the focus of my objection. They will see one illustration that is no more meaningful than many other non-illustrated versions of what these shots might be. I understand that the court has ruled. I will shut up. The court says, well, no, don't shut up. Let's go on to the 1118 motion. Mr. Gessler says, may we have just a couple minutes? Ms. Abramson says, I just want to take some aspirin. The court says, sure, sure. Brief pause in testimony. Mr. Gessler says, I meant I will shut up on that subject. The court says, okay, let's go on then to the motion pursuant to section 1118. Mr. Gessler says, yes, Your Honor, my motion pursuant to 1118.1 actually goes to the lying in wait special circumstance. And at this point, that's the only thing that I'm addressing, and I'm addressing it on two grounds. The first is on the 6th, 8th, and 14th Amendments, Your Honor. That's the lying in wait special circumstance, as presently enacted by statute and by judicial interpretation of that statute in California. Do not serve the required narrowing purpose that qualifiers for a death penalty must have under the United States Supreme Court law, particularly Zant versus Stevens and other cases that have followed it, that a special circumstance in California or whatever we call it in some other state, whatever it is that is going to separate an ordinary first degree homicide from that makes somebody death eligible, must serve a narrowing purpose. It must do something to discriminate those from to discriminate from those who are worthy to be considered from death from those who are not. And although lying in wait, as words may have some meaning in serving as a qualifier, the California State Supreme Court's interpretation of what that means or what can constitute lying in wait have now come to the point where it doesn't even take a very imaginative district attorney to take any first degree murder that they want to and turn it into a death eligible first degree murder case by adding the special circumstance of lying in wait. Do you think that was a tactical decision on their part, on the state's part, since he's throwing around tactical decisions? Do you think that was a tactical decision on their part to add the special circumstance of lying in wait because they could? Because this new interpretation by the California State Supreme Court says it or easily allows DAs to add that charge on. Seems maybe that might have been a strategy. Traditionally, of course, lying in wait was considered to be more heinous than other crimes because it connoted and really meant in the law the guy who was lying down concealed by the sagebrush and shot the rioter as he was coming by. A concealment not only of purpose but of the person from the intended victim, an actual waiting for him to come by and then killing him from ambush. An ambush killing is, in that sense, has been considered to be more heinous than others. Then we had the Morales case, and of course, that was a person whose purpose was concealed. Even though the person wasn't concealed, he was in a car sitting behind the person that he intended to kill, that he said he was going to kill to others, and then he tried to hammer her, strangle her, beat her, everything that it took in order to kill her, and succeeded. And the Supreme Court said, well, that's all right for lying in wait, too, because we have the concealed purpose and the watchful waiting. But even then, the watchful waiting and the concealed purpose and the killing all have to be temporarily related. Temporally related. They have to occur immediately as the watchful waiting ends. So it has to be relative in time. And then we get into People versus Hardy, and in Hardy, the only real reason that that was found to be a lying in wait is the crime occurred at 3:30 in the morning, and so they inferred that there was watchful waiting, presumably waiting for dark and the people to be asleep so that the killers could unscrew a light bulb, gain entrance into the house, creep down a passageway, and kill the sleeping victims. Again, this did not narrow in any sense any first degree murder in which there's premeditation and deliberation. Premeditation and deliberation almost always includes waiting and watching. And then we get into the Edwards case, and in that one, it just said, well, it doesn't have to be a very long period of watchful waiting, seeing a potential victim from the camper and then getting that victim and killing them. That's enough for lying in wait. The problem is now that anybody who does not call up the potential victim in advance and say, I'm coming over to kill you, and here's how I'm going to do it, and when I'm coming, would be thought to be a watchful waiting and lying in wait, and would meet the test as it's presently non defined by the California Supreme Court. He makes an excellent point. This argument obviously doesn't work, though, because they were charged on the lying in wait charges, or convicted, I should say, found guilty of. There was almost nothing that would not make it. It doesn't make any notice under the Due Process Clause. It does not guide or give any principled method or identify a class of murderers more deserving of death than anybody else who premeditates and deliberates their crime. It does not serve a constitutional narrowing purpose. And for that reason, I think that the special circumstance, regardless of the facts of any case as they are now to California, not just this case is irrelevant to this particular motion. It is that the term lying in wait, the special circumstance lying in wait, is void for vagueness, void for lack of judicial definition to serve the narrowing function. It's void under the 6th, 8th, and 14th Amendments and Stevens versus Zant because it is just too amorphous, covers too many situations, and all it means is, gee, I'm not telling you that I'm coming to kill you. That is insufficient under the constitutional provisions to serve as a qualifier for a death penalty under California law or under federal law. That's the first prong of the motion, Your Honor. If the court wishes, I will give the second prong at this point. He says, let me respond to this aspect first. All of the arguments that you make to this court have been made to the California Supreme Court and have been rejected. And this court, Mr. Gessler says, they blew it. The court says, this court is bound by the ruling of the California Supreme Courts, which have held that the lying in wait special circumstance is sufficiently defined to meet constitutional standards, and therefore this court is bound by those rulings, and on that ground your motion is denied. Mr. Gessler says, Your Honor, I think this court is also bound by the United States Constitution and the amendments thereto, and although the United States Supreme Court has not ruled directly on this point in our favor, and it denied cert of Morales, I think, but that's just a denial of cert. You can't read much into that. There is no so they decided not to hear the case, basically. So there is no defined decision on this particular portion of California law as yet by the United States Supreme Court, and we certainly have been invited by the Tulipa, I have no idea how to say that, by some county, I think. We were invited by the something decision, the concurring opinion by Justin Blackman. Even though he's no longer there, he certainly invited us. He said, why aren't you attacking the narrowing function? Why was that conceded in this case? And that was under the 21 special circumstance just as a generic class. Lying in wait is the one most susceptible to this argument of all of those different special circumstances because it alone is constitutionally unfirm. So, the court says, I understand that this is an issue of federal as well as state constitutional basis, but at the same time, the court is bound by precedent, and the ruling of the court is, as I've stated, the motion on the ground is denied. Mr. Gessler says there is a further ground, Your Honor, under 1118.1. Again, as to the lying in wait special circumstances, and that is for insufficiency of the evidence of the case, at the conclusion of the people's case to prove the lying in wait special circumstance or to be upheld on appeal, again, the reasons for that are that if it is to be found that there is sufficient evidence to support it on appeal, it has to meet the constitutional test of what is sufficient evidence to meet a constitutionally defined lying in wait qualifier or special circumstance. And in this case, all we know from the people's case is that these two young men, or at least arguably these two young men, went down to a Big Five store in the La Jolla area, 100 miles from the area of their home, passing up other stores, used a false identification to buy two shotguns, and that their parents were found shotgunned to death with multiple shotguns in their living room. And at this time, they were found. Mr. Menendez was seated on the couch, and Mrs. Menendez was lying with numerous fatal shotgun wounds between the couch and the table, and that there is a statement, a tape recorded statement to a Dr. Oziel talking about having done the killings. For whatever reasons, mercy killing crept in. Dr. Oziel used the word control. There was some talk about not letting it happen until they slept on it. There might be some proof of premeditation and deliberation. There might be some proof that this court could find even some type of watchful waiting, although it stretches it greatly to say there was a watchful waiting for 2 days and nights between the time of the purchase of the shotguns and the killings. We do not know the positions of the particular decedents at the time that the shotgun blasts were first delivered. There might be some circumstantial evidence in the people's case at the time that they were presented from the blood and the different pictures that have been presented, that it occurred in a reasonably confined area of the sofa, the coffee table, that area of the den, but that's all we have. What we do not have is the nexus between watchful waiting, if there was any, and the actual killings. We have no knowledge as to what precipitated these particular killings at the time that they occurred in that room. And I believe, Your Honor, that there is insufficient evidence under 1118.1 to find a valid constitutional lying in wait provision at this point. Ms. Abramson says, I join the counsel in counsel's remarks on behalf of Eric Menendez. The court says, okay, did the people wish to respond? Mr. Khan says, yes. Here we have it can be inferred from the crime scene that from photographs of the victims of the crime scene, as well as from facts that the defendants purchased the shotguns 2 days earlier, as well as from the fact that from the admission of the defendants in the December 11th tape, what the defendants did was purchase the shotguns 2 days earlier, that they premeditated during that period of time, and that they waited for the opportune moment to kill their parents. We know that the victims in this case were killed on a Sunday evening at 10 p.m. or while relaxing in their home while watching television. We know that the position of the bodies, particularly that of Jose Menendez, strongly leads itself to the conclusion that they were totally caught off guard and taken by surprise at this their vulnerable moment. We have the admissions of the defendants on the December 11th tape that they did premeditate this crime for a couple of days. It could reasonably be concluded that following the 2 day period of premeditation, they waited for the right opportunity to strike. And what proof do you have that they did that? And also, we have the testimony of Dr. McCarthy, as well as part of our case, that the victims, in his opinion, were sitting down at the time that the first shots to the victims were fired. What? As well as part of the case that the victims, in his opinion, were sitting down. Oh, Dr. McCarthy's opinion. Sorry, I blanked there. I didn't catch that he was talking about Dr. McCarthy's opinions. I thought he said the victims, or not the victims, the defendants. I thought he said the defendants said that the parents were sitting, but that's not true. Dr. McCarthy says the parents are sitting. Many others dispute that. Many other experts for the defense dispute that. So, given the circumstances of the shootings, that is, a Sunday night, 10 at night, relaxing in front of the television, that after the defendants had 2 days to premeditate this crime, it only reasonably can be concluded the premeditation was followed by watching and waiting, and they did strike the victim at a most vulnerable time, and that supports sufficient evidence to support the charge. Mr. Gessler says, maybe I missed something, Your Honor. Where are the words that they waited for the opportunity in the December 11th tape? You're asking me or Mr. Khan? Says the court. And Mr. Gessler says, well, I'm asking you because I can't talk directly to Mr. Khan, but I have reviewed the tape, and that might be an inference that he is somehow stretching from that tape. But I don't remember the words from either Eric Menendez nor Lyle Menendez saying that we waited for the opportunity to get our parents or that we caught them lying out in front of the TV set or any of that. What Mr. Khan had said is exactly what I've been arguing on a constitutional basis earlier. He has taken premeditation and deliberation, said we had some proof of that from the tape, we have some proof of that from the crime scene, and then he has equated it to mean lying in wait, and that covers it. The objection I have is there is no evidence for a valid constitutional lying in wait special circumstance. I'm not talking about whether there's enough to go forward on the first degree theory. The court says, all right, the issue is whether or not there is sufficient evidence to sustain a conviction on appeal, and the issue is more narrow, as addressed by counsel, whether or not there is sufficient evidence to sustain a finding by the jury beyond reasonable doubt that the special circumstance of lying in wait has been approved. The court does not evaluate it based upon proof beyond a reasonable doubt, but just whether or not there's sufficient evidence if the jury was to find there's sufficient evidence, if the jury was to find against the defendants, and not for the prosecution of this special circumstance, whether or not an appellate court would sustain that finding on appeal. And the court concludes that an appellate court would do so, and there is sufficient evidence represented by the prosecution to sustain a conviction on an appeal on the special circumstance of lying in wait. Therefore, the motion is denied. Anything else? No, Your Honor. So he denied the motion to exclude the evidence, the garbage diagrams from Dr. McCarthy. Those are coming in. Those were the defense was denied, and now trying to get rid of the special circumstance charge of lying in wait. They were unsuccessful. Obviously, we knew that because they were charged with it or convicted of it. But um, I think he had a valid point. Where's the evidence that they were lying in wait? There is none. So I think this was an incorrect ruling, and also I'm sure it was upheld later. I'm sure it was argued in appellate courts later, and it was upheld by the higher courts, I guess. He says, all right, anything else? Mr. Gessler says, no, Your Honor. The court says, we have one issue that we talked about yesterday with Mr. Levin. We can pursue that. Any other issues here that we can address before we take our break? Schedule wise, I talked to you about that briefly yesterday. The people weren't present, so perhaps I don't know if they're aware of what your schedule is. Witness schedule. Ms. Abramson says, right now we're going to have Dr. Wecht back. We keep re-interrupting witnesses. I have to have Dr. Wecht on Monday, and I imagine part of Tuesday. Mr. Morton will be available, we hope, right after Dr. Wecht, so we'll let him know Monday night if we want him in Tuesday or Wednesday, and so they're next. And then, as we call them, the boat people, and then Eric Menendez. The court says, how much longer do you think you had on Mr. Morton? Ms. Amerson says, I thought I only had an hour and a half or so, but I can't predict what Mr. Khan has, and my intention with Dr. Wecht has to be relatively brief. We already told you what my plan was told the court that my plan was with Dr. Wecht. I'm going to take very long with him either. Oh my God, I can't read. Good thing this is almost done. I'm not I'm not going to take very long with him either. It's the cross-examination that might take up a long time. The court says, okay, all right, then let's take our recess and we'll have a continuation of that closed hearing with the defense and we'll be in recess until Monday at 8:30. Ms. Abramson says, thank you, Your Honor. And we are done. So that is the end of their argument that they had on December 1st, 1995. We will continue back here tomorrow with Dr. Cyril Weck's testimony and go from there, like I said, and we'll just keep on going and see. It's kind of confusing right now that their witnesses are all out of order, but it'll start to even out and make sense. So hopefully it's not too confusing. All right. Well, thank you guys so much for watching. Please don't forget to hit that like button on your way out if you haven't done so already, and I will see you guys in the next one. Take care.